Good morning. I want to start today by thanking you for joining the Commodity Exchanges, Energy and Credit Subcommittee for our first meeting of 2016. As many of you may remember, the full House on Agriculture held a hearing last July on the implementation of Dodd-Frank over the 5 years since it was passed. That hearing highlighted some of the remaining challenges that regulators must still tackle to complete the derivatives market reforms envisioned by world leaders in the aftermath of the 2008 global financial crisis. The purpose of today's hearing is to dive deeper on one issue in particular, and that is the status of swap data reporting goals and to better understand what work remains to be completed. In response to the crisis, a crucial goal of the G-20 financial reform commitments was to bring about greater regulatory transparency in the over-the-counter derivatives marketplace. With that focus, the United States broad data collection requirements for OTC derivatives and established swap data repositories to collect and maintain swap data under the Dodd-Frank Act. The 5 years since the enactment of Dodd-Frank have seen some significant progress, I should say, in the reporting of the OTC derivatives trades and several clear victories in the quest for market transparency. However, this progress remains uneven and major gaps remain in translating that progress into data reporting to meaningful market oversight. Data collection alone is not sufficient to achieve the goal of increased regulatory transparency. Real insight into global systemic risk requires that regulators be able to aggregate data accurately from different SDRs here in the United States and across global jurisdictions. Market participants have raised serious concerns about the status of regulatory transparency efforts. This committee has heard testimony about the lack of common data standards and common reporting standards. This lack of standardization unfortunately falls at many points on the reporting spectrum, from inconsistency among global regulators on trade reporting requirements to undefined data collection requirements from the CFTC. Even something as simple as a defined way to record a date hasn't been established. Imagining the variety of possible variations for that one simple data point, do you start with the month or do you start with the year, helps us illustrate the issue at hand. I think we all agree that there is little regulatory value in non-standardized, non-aggregatable data. The question at hand then is how to continue moving the ball forward to achieve needed market transparency, and importantly, how to do so without forcing artificial standardization and a one-size-fits-all approach onto a highly customized market, especially in regard to the non-financial commodity swaps relied upon by end users for risk management. We hope to leave this hearing with a better understanding of the progress made towards meeting the reporting and transparency goals set forth by the G20, as well as market participants and the CFTC's role in that process. In the end, the success or failure of our financial reform efforts cannot be judged by the list of rules finalized by the CFTC. Real reform requires coordination between global regulators to create a coherent system of regulation that fosters market access and promotes market integrity. We're fortunate to be joined by a panel of distinguished witnesses here to share their views from both the regulatory and market participant perspectives. Thank you to each of you for appearing before us today. We look forward to hearing your perspective on these issues and appreciate the time and effort you've put forward to be here. With that, I'll recognize our ranking member, Mr. Scott, for any remarks he would like to make.
Thank you, Chairman Scott. Getting data on swaps is one of the three main goals of Dodd-Frank. The lack of data to form an overall picture of what is happening on the markets was a major contributor to our financial crisis. This hearing is an excellent follow-up to the Dodd-Frank at 5 years hearing we had in July, where we aimed to make inroads to completing the G20's vision of implementing clearing, margining, electronic execution, data reporting, and capital standards. Here before us now today is the challenge of getting aggregate data from many repositories in many different jurisdictions. I agree with the Office for Financial Research, who noted that good data are essential for good policy decisions, and data gaps and lack of data access hinder policymakers, hinder supervisors, and hinders regulators from understanding and addressing the vulnerabilities in individual institutions' markets across our financial system. The CFTC has an important mission and will be unable to complete it without a data system that works for those reporting as well as the CFTC using the data. I'm happy today to see every part of this industry represented here with the panel from every part of the data collection process, and I'm confident that with input from everyone involved, we will be able to put together a system that works. So I'd like to thank you, Mr. Rogers, you, Ms. Cruz, Ms. Galosa, and Mr. Gill for being here today, and I look forward to hearing your testimony. Thank you, Mr. Chairman.
The chair would request that other members submit their opening statements for the record so the witnesses may begin their testimony and assure that there is ample time for questions. The chair would like to remind members that they will be recognized for questioning in order of seniority for members who were present at the start of the hearing. After that, members will be recognized in order of their arrival. I appreciate members' understanding. Witnesses are reminded to limit their oral presentation to 5 minutes. All written statements will be included in the record. You should have a timer in front of you that's pretty accurate. And now I'd like to introduce the witnesses. Mr. John Rogers, Chief Information Officer, Commodity Futures Trading Commission, Washington, D.C. Ms. Tara Cruz, Co-Head of Data Reporting for FPML, ISDA, New York, New York. Ms. Marisol Colazzo, I apologize, Managing Director and CEO of DTCC, Data Repository, Depository Trust and Clearing Corporation, New York, New York. And Mr. Andres Gill, Director of Center for Capital Markets, Competitiveness and Representative, Coalition of Derivatives End Users, Washington, D.C. Mr. Rogers, please begin when you're ready.
Thank you, Chairman Scott, Ranking Member Scott, and members of this subcommittee. I am pleased to update you on the CFTC's progress in achieving the G20's swap data reporting goals. I am the director of the CFTC's Office of Data and Technology and serve in the role of Chief Information Officer. In this capacity, I oversee the technology and data functions of the Commission. As you know, increased data reporting was a key objective of the G20 agreement and Dodd-Frank. The CFTC has made significant progress since 2008, where there was virtually no reporting of swaps positions or transactions. During the crisis, a lack of data made it difficult for regulators and market participants to assess the exposures and interconnectedness of major institutions. Today, all swaps, whether cleared or uncleared, are reported to swaps data repositories. Public websites are providing price and volume information for individual swaps transactions in real time. This facilitates efficient price discovery for all market participants, including end users such as farmers, ranchers, and commercial businesses of all types. As a regulator, the CFTC's ability to oversee the swaps market has dramatically improved. But building this system is complicated and an ongoing task. It is time and resource intensive, requiring constant updates and refinements as we understand the data better. As a result, the Commission is working to ensure the data it receives is clean, consistent, accurate, and timely. It is collaborating with market participants to analyze exactly what data should be reported, how it should be reported, by whom, and when. And the agency is working with industry and other nations to harmonize and standardize our efforts. One of the issues the CFTC is taking action to address is the variation in how the same data from different counterparties is reported. This causes problems when it comes to aggregating and analyzing this information. To address this issue, CFTC staff recently requested public comment on technical specifications for the reporting of 120 priority data elements. This followed months of work to identify areas where standardization or clarification is needed. From this feedback, the Commission will develop proposals that specify the form, manner, and allowable values that each data element may have. In fact, just this week, the Commission held a public hearing of the CFTC's Technology Advisory Committee to discuss this issue, among others. The Commission is also working towards obtaining complete data. Some required fields are not reported by participants, and SDRs do not believe they have the authority to reject data if it is incomplete. CFTC Chairman Massid recently underscored his belief that the CFTC should change its rules so that SDRs have a greater ability to improve the quality of data before it arrives at the CFTC. Staff is looking closely at this possibility. Further, the CFTC is working to develop a uniform, effective means to identify swaps and swap activity by participant, transaction, and product type throughout the swap lifecycle. And we are at the forefront of addressing all these issues internationally. I am pleased to co-chair the international task force that is leading global harmonization efforts. Finally, the Commission continues to fine-tune its rules to clarify which entities have an obligation to report data and what data must be reported. It is paying particular attention to the needs of commercial market participants, ultimately working to eliminate reporting obligations that are not necessary. Thank you, Mr. Chairman and members of this committee. Let me conclude by reiterating that this swap data reporting effort is a significant global undertaking. Completing it properly will take time, but I believe the agency has made significant progress in just a few short years. Thank you again for inviting me. I welcome your thoughts and questions.
Ms. Cruz? Ms. Cruz?
Chairman Scott, Ranking Member Scott, and members of the committee, thank you for the opportunity to testify today. My name is Tara Cruz, and I am co-head of data reporting and FPML at the International Swaps and Derivatives Association. A central component of the G-20 commitments in Pittsburgh was the reporting of derivatives to trade repositories in order to increase transparency and enable regulators to spot risk concentrations. Recognizing derivative markets are global, the G20 committed to use consistent standards in order to avoid fragmentation and regulatory arbitrage. Substantial efforts have been made toward realizing these commitments. Today, derivatives trades in the U.S. are reported to trade repositories, and an increasing number of transactions are reported globally. Despite these advancements, U.S. regulators have struggled to fully understand and optimize the data being reported and are not in a position to have a complete picture of either domestic or global risk exposures. This visibility is impeded by the failure to use globally consistent standards that facilitate efficient, accurate data reporting that is suitable for aggregation and systemic risk analysis. Contributing to the challenge is the fact that each regulator has developed a unique set of reporting requirements and devised its own list of reportable data fields. This not only makes reporting complex and more costly for derivatives users, but it means the data cannot be aggregated to obtain a clear view of global derivatives trading activity. Let me illustrate this important point with a very simple analogy. Imagine if every car dealership in the US and around the world was required to report basic facts about each and every car that it sold, including the car's size. Due to differences in regulatory oversight of these dealerships, some dealers reported size as the car's weight, others as the number of passengers it held, yet others as its length or its horsepower. The solution is for regulators to work together and with the industry to agree on a core list of systemically important data fields that are reported in a consistent manner based on existing data and messaging standards. ISDA stands ready to help in this regard. We've worked to develop standard taxonomies and standard messaging language, and we're currently leading an industry initiative to develop standard product identifiers. ISDA and its members would suggest several concrete steps that could be taken to improve data reporting and systemic risk monitoring, while at the same time reducing the cost and complexity for market participants. First, CPMI IOSCO should lead global data harmonization. Agreement on common data standards should be achieved in coordination with the efforts of the harmonization group of global regulators established by CPMI and IOSCO. This group has issued consultations on standard transaction and product identifiers, as well as reportable data elements. Consistency on these standards is key to achieving greater harmonization. It's important the CFTC and SEC are aligned with this global initiative and do not engage in further overlapping and potentially contradictory data proposals. Second, data fields should be specified and based on existing market standards. Regulators should work with the industry to ensure regulatory requirements closely align with prevailing industry-defined terms and practices. All data elements required by regulators to meet their objectives should be explicitly specified in the regulations. Existing derivatives messaging standards, such as Financial Products Markup Language, or FPML, should be leveraged where possible. Third, domestic regulators should align on data rules. Given that both the CFTC and the SEC developed reporting rules in response to the same piece of legislation, the rationale for issuing different requirements is difficult to comprehend. The split between swaps and security-based swaps undermines the ability of the commissions to aggregate their data and provide Congress with a holistic view of risk in the U.S. derivatives market. Finally, reporting requirements should be rationalized and streamlined. Regulators should determine what data they need to monitor systemic risk and simplify reporting requirements accordingly. Certain data fields are currently required to be reported or proposed to be required that offer little insight into risk. This increases the volume of data that needs to be analyzed to little benefit and increases the cost and complexity of reporting, which in turn undermines data quality. Regulators should agree on a meaningful set of globally consistent data fields that enables them to meet their regulatory objectives. Regulators should also assign the sole responsibility for both the reporting of data and the accuracy of the data for a transaction to a single party which is best situated to do so, thereby reducing the cost and burden to end users. Thank you for inviting me to speak today on this important topic. ISDA is a strong proponent of improving the accuracy, consistency, and efficiency of transaction reporting while mitigating its costs and burdens. We stand ready to help. Thank you.
Ms. Colazzo.
Thank you, Chairman Scott, Ranking Member Scott, and members of the subcommittee. I'm Marisol Colazzo, Managing Director at DTCC and Chief Executive Officer of DTCC's U.S. Swap Data Repository. I appreciate the opportunity to share my perspective on the current status of swaps data reporting. In 2009, G-20 leaders committed to making the global OTC derivatives market safer and more transparent. This transparency will assist regulators globally to monitor systemic risk forming in the swaps market. Swap data repositories, or SDRs, emerged as a way to achieve this goal. Since then, progress has been made and trade reporting regimes are in place across all major jurisdictions. Today, authorities have access to more data than ever before. In the U.S., we process 80 million messages a week, or more than 4 billion messages a year. In order to assess the effectiveness of trade reporting, we must refer back to the two goals of the G20 mandate. One, to provide transparency into opaque markets, and two, for regulators to utilize such transparency to identify and anticipate potential systemic risk. There are aspects of the data being reported today that are useful to both the CFTC and the public at large. For example, public price transparency is now reported on a real-time basis. This provides a window into a market that was previously opaque. From this data, the CFTC can see volumes and the number of transactions executed daily. Further, the CFTC has an even deeper view of reported data that can be used for surveillance and other regulatory purposes. Now let's turn to the challenges that remain. Given that the swaps market is inherently cross-border, in order to fully maximize the usefulness of the data reported to SDRs, a globally consistent framework for standardization and governance are needed. Today, unfortunately, inconsistent reporting requirements amongst various jurisdictions are hindering this ability. Global data harmonization and regulatory access to data remain a challenge. DTCC applauds Congress for removing the Dodd-Frank's indemnification provision. However, more work remains. These challenges must be resolved before regulators can effectively aggregate data and determine the systemic risk profile of a global swap dealer. Based on DTCC's experience supporting regulatory reporting across 9 jurisdictions, we have seen divergent requirements even within the same data elements. This variance has negatively impacted data quality and increased complexity. Instead, we recommend that regulators agree to a standard approach for reporting the core terms of the swap across jurisdictions. Such global consistency will facilitate efforts by regulators to share and aggregate data, allowing for a more complete and harmonized view of the OTC derivatives market. The CFTC recently issued a request for comment on technical specifications for the reporting of certain data elements. DTCC strongly encourages the CFTC to recognize existing market convention in its effort to improve currently reported data. The CFTC should carefully consider if any proposed changes significantly add value or if they inject unintended complexity into the current reporting system. We also encourage the CFTC to align with policymaking efforts underway globally, such as those spearheaded by CPMI IOSCO, to establish consistent data standards. For example, much progress has been made on establishing a recommended standard for product and transaction identifiers. We look forward to the remaining work that CPMI IOSCO will take on for other key data elements. Another important step is the establishment of a governance framework to facilitate management of this global data set and regulatory access to data. This framework will help ensure that standards are maintained and updated as markets evolve. In conclusion, the priorities I have outlined will assist in realizing the G20 goals of market transparency and systemic risk oversight. We believe that Congress must ensure regulators remain focused on implementing such framework as I've described. Thank you, Mr. Chairman, for the opportunity to present and participate in today's hearing, and I look forward to your questions.
Thank you, ma'am. Mr. Gill?
Thank you, Mr. Chairman, Ranking Member Scott, and members of the subcommittee for the opportunity to testify at the hearing to review the G20 swap data reporting goals. My name is Andre Skill, and I am testifying on behalf of the U.S. Chamber of Commerce and the Coalition for Derivatives End Users. The Chamber is the world's largest business federation, representing the interests of more than 3 million businesses of all sizes, sectors, and regions. The coalition includes more than 300 end-user companies and trade associations. Collectively, the Chamber and the Coalition represent a wide and diverse population of domestic and international commercial businesses and trade associations. At the outset, let me thank the members of this subcommittee for their focus on balancing regulations to promote financial stability and for Main Street businesses to have the tools necessary to operate and grow, as well as the CFTC for listening to the concerns of end users and for creating a data reporting regime that is both robust and sensible. The Chamber believes in America's global leadership in capital formation and supports capital markets that are the most fair, transparent, efficient, and innovative in the world. As part of that mission, we recognize the acute need for commercial end users to effectively manage risks. This should be consistent with financial regulatory measures that promote economic stability and transparency without imposing undue burdens on derivatives end users. With that background in mind, we support and believe in the G20 swap data reporting goals, including improving transparency in derivatives markets, mitigating systemic risk, and preventing market abuse. But there are real economic consequences of getting derivatives regulation wrong. Main Street businesses use derivatives to obtain access to raw materials, lock in prices for commodities, and mitigate risk. Many U.S. companies are able to maintain more stable and successful operations through the use of a variety of risk management tools, including derivatives. Smart regulation should encourage, not discourage, such practices. However, implementation of the G20 goals has begun to hurt end users. For example, the European Union appears to be proceeding without due regard for the economic and regulatory burdens imposed on end users by certain swap data reporting obligations. These include dual-sided reporting and intergroup obligations, which require end users to adopt costly new reporting systems to comply with EU law. Both requirements impose significant initial and ongoing operational, legal, and cost burdens for end-user companies. We suggest that there must be a better way for regulators and the market to get the data they need without imposing duplicative and burdensome regulations on real economy companies, especially because they do nothing to promote the goals of the G20 framework. Ultimately, the Chamber and the Coalition believe that disparate treatment has resulted in a fragmented market where U.S. end users operating abroad now face compliance with multiple reporting regimes and require data sets for their transactions. The larger point, however, is that the cumulative effect of new derivatives regulation threatens to impose undue burdens on end user hedging. Both the direct regulation of end users through reporting requirements, on which this hearing is focused, and indirect regulation, such as capital and liquidity requirements imposed on our counterparties, serves to discourage end user risk management through hedging. We need a regulatory system that allows Main Street to effectively use derivatives to hedge commercial risk, resulting in key economic benefits. One that allows businesses to improve their planning and forecasting, manage unforeseen and uncontrollable events, offer more stable prices to consumers, and contribute to economic growth. We should always aim to avoid the imposition of unnecessary burdens on end users that restricts job growth, decreases investment, and undermines our competitiveness abroad. As the subcommittee considers the implementation of G20 reporting obligations, it is our hope that these issues will be at the forefront of your efforts. Continued support for global standards, rather than proceeding on divergent paths, is important for data reporting consistency. Congress has the ability to influence that process by promoting harmonization and the sensitivity to the impacts on end user companies. Together, we can strengthen our financial systems by supporting Main Street business. Thank you, and I'm happy to address any questions that you may have.
Thank you. I have several questions, as I know the other members do as well. I'll start with, this will be for Ms. Cruz and Ms. Colazzo predominantly. In its 2010 report entitled Implementing OTC Derivatives Market Reforms, the Financial Stability Board stated authorities must have a global view of the OTC derivatives markets through full and timely access to the data needed to carry out their respective mandates. This recommendation helps achieve this objective, including that trade repository data must be comprehensive, uniform, and reliable, and if from more than one source, provided in a form that facilitates aggregation on a global scale. Ms. Cruz and Ms. Colazzo, why has the Financial Stability Board been so concerned about regulators having a global view of the swaps market, and how do their recommendations help achieve that objective?
Thank you, Mr. Chairman. I can start. I think it's really back to the statement that was made earlier. These are global markets, and you may have market participants in your jurisdiction that trade transactions that may seem explicit to the U.S. markets, but in fact, a lot of their trading activity and many of their affiliates may cross over into other regions. And so to understand really the risk that that particular entity and its affiliates hold, you need to have a broader view of trading activity.
Thank you, Mr. Chairman, for that question. It is an excellent one because it's one that's often discussed. And, adding to what Tara just described, it's one about understanding all the activity. These financial companies have many entities and making sure that the regulator can see the activity of the entity across, at the parent level, across all of the subsidiaries branches that they may have. But there's another important point here as well, particularly as it relates to credit default swaps. And Lehman crisis was a classic example of that. Lehman Brothers was an entity as well that was, for credit default swaps, that was the underlying security. And that transaction could occur between two non-US entities. And during that crisis, there were rumors that the outstanding debt that firms would have to pay with Lehman going bankrupt was over $400 billion. Well, we were actually able to look at the contracts because we offered a post-trade processing service that had all the global data. And we saw that through aggregating that, it wasn't $400 billion, it was $6 billion. But the important point here is that these are contracts that neither side was a U.S. party, yet had a significant systemic impact. And that, to me, is a sort of classic example for why regulators need to be working together globally, because these are inherently cross-border trades, and there are going to be trades outside our jurisdiction that is going to be relevant, particularly in a time of crisis, for our authorities to be able to see that information. Thank you.
Were you able to see that difference immediately, the difference in the $400 billion and the $6 billion?
So it was speculation of the $400 billion notional. There was rumors, essentially, that the payout on Lehman bankruptcy for credit default swaps by those who held these transactions and had sold protection, they would have to pay at time of auction, north of $400 billion. DTCC was uniquely positioned at that time because we were providing post-trade. We were essentially performing the management of the operations of the credit default swaps. And so we took that data and we looked at the payments if the auction occurred. And the number was not $400 billion. We identified that if the auction was zero recovery rate, the amount would be $6 billion. In fact, when the auction for Lehman occurred, the exchange of payments was $5.2 billion.
If I can't, did that take a day? Did it take a week? Did it take a month? How long did it take you to determine that it was going to be $6 billion, not $400 billion?
A very long, painful day.
A day. Thank you. I'll recognize Mr. Scott from Georgia for any questions he may have.
Yeah, thank you, Mr. Chairman. Miss Galasso, did I do that right?
Yes, you did, right?
Wonderful. I was very intrigued by your testimony. But I too agree with you. The cross-border harmonization issue is very critical. Share with us a moment, because you talked about the 9 jurisdictions that you have. Tell us what those jurisdictions are. And then I think you mentioned the workload capacity of, did you say 80 million? I didn't get, was that 80 million per year, and then, or was it per day? And then what is that other figure? In other words, what I'm trying to get at is the enormity of this problem and why the issue of transparency is so critical to identifying systemic risk. But the good starting point is that you're right there sort of in the wheelhouse, and that was a profound amount of work that you issued before us. Could you elaborate on those points?
I'd be happy to, and thank you for that question. It's certainly at the heart of what I was trying to communicate regarding the enormity and the global impact, so appreciate it. I don't know why, perhaps if I move it away a little bit. Is that better? Okay. Okay, hopefully it's not me. Is that better?
Yes,
okay.
Very much so.
So in answer to your first question, as it relates to 9 jurisdictions, these are represents the U.S. under the CFTC. We also cover reporting in Europe under the ESMA regulations. We're also in Australia, Singapore, and Japan. And we support reporting for 3 Canadian provinces. And so we've been uniquely positioned really to look across that data set and identify where those divergences exist. When I speak about sort of the enormity of the data that's coming in, the 80 million messages a week that I described as it relates to US volume coming through really is to sort of set the context of how much activity, messages are just coming through. And, this is something in terms of data standards that becomes so important when you see this size of information. In terms of globally, what we support for these 9 jurisdictions, we see approximately 300 million a week. Mm-hmm. So this is big. And when we sort of think about how we arrive at reliability, usability of the information, it's not a one-size-fits-all. It has to be a means where we can, and my colleague Tara Cruz mentioned this, where we can leverage existing market conventions. In that example of the 400 billion and the 6 billion, why were we able to aggregate that information in a day? Because we had the data held in a highly standard way for credit default swaps.
I want to get to my other point. I got about a minute left. I want to ask, how difficult or expensive is it, given all of what you're talking about there, for smaller players in these markets, like our end users? And Mr. Gill, you may chip in here too, because that's where the rubber meets the pavement for us, is the complexity of what this makes for our end users to interface with the SDRs and accurately report swaps data.
So I'll say a few brief words, and then I'll let Mr. Gill respond to that as well. The work that we're proposing here will actually drive efficiency, remove complexity, and ultimately that will benefit the end users. And in fact, I would even add, would enable them to have a level of transparency into this data being reported that would support the efforts both from the G-20 goal as well as end users actually having some benefit here.
I would definitely associate myself with those comments. I would also underscore there's a mistaken kind of assumption that reporting simply means sending an email by an end user. That's completely wrong. What actually occurs for an end user is the creation of a system, a computer system usually from scratch, very costly, and usually not in the best position for someone to actually report. So I would say that the costs are tremendously high.
So you don't see, for example, end users having an exemption from this?
Under the current rules, end users, under single-sided reporting would rely on their financial counterparties to do the reporting. Obviously, under the dual-sided reporting in other jurisdictions, we have a lot of concerns.
Okay, thank you, sir. Appreciate it.
Mr. Nagelbauer.
Thank you, Mr. Chairman. One of the things that, as I sit on this committee and the Financial Services Committee, and we've been dealing with a whole plethora of regulations that came out of Dodd-Frank, is that, changing the business model and the market behavior. And one of the things that I've been particularly concerned about is the liquidity in some of these markets. Markets do not perform well if they don't have the right amount of liquidity. And what we've seen is that some of these regulations have changed market players' behavior. We've seen some players get out of the marketplace. And so one of the things that I'm a little concerned about is this recently drafted technical specifications creates a pretty detailed and highly prescriptive set of standards on how to report each and every trade. And I'm afraid that might not be all that easy for some of the non-standard hedging products. So I guess, Ms. Cruz, do I have a valid concern that with all of these changes that we're making and that we're changing market behavior a little bit and potentially have a liquidity issue?
Congressman, yes, I would absolutely agree with that. I think sometimes we go in the wrong direction. There's a misconception that more data is better data, but I think it's better to stick with a core set of data fields that allow you to understand the market risk of the transactions and focus on improving those before looking to expand the requirements.
Mr. Gill, I'm also concerned about this increased reporting requirements, and we were talking about end users, as Mr. Scott brought up on the swap market. But I think about adding 120 additional data fields and having to compile the data and report the data on each and every trade. That that's particularly for smaller end users. To me that's problematic. Am I missing something here?
Congressman, we share your concerns completely. I think the CFT's proposal, while well-intentioned, does ask for a number of additional data fields that will impose additional costs, and those costs obviously flow down to end users. To the extent that a financial reporting party has to start collecting that information, it does go to the end user. And the number one thing that we want to avoid is pricing the end user out of the market because of increased costs.
Yeah, I think one of the things that I wonder is if the requirements are maybe well suited for reporting for the could perhaps be more suited for the swap dealers themselves rather than putting that responsibility on the end user. Is that a reasonable thought?
Congressman, I think that's a great question. Honestly, the costs do end up flowing to the end user regardless of who is the reporting party. That's, we've seen that in a number of different regulations, whether it's capital or margin, and it applies to reporting too. I think that the important thing to do, honestly, in addition to making sure that the right person and the right party is actually reporting this information, is making that information as targeted as possible, eliminating issues with current reporting issues, and then only asking for data sets that are truly needed going forward.
Yeah, I think one of the things that, because I heard you say a while ago, it's pretty expensive, the startup, and so I'm thinking that the infrastructure that the swap dealers already have in place may be a more cost-effective place to do that rather than asking the end users to have to develop that infrastructure.
Congressman, I would agree with that.
Yeah. So I think the final point that I wanted to make is that, I'm extremely concerned about all of these new, as we've gotten this new regulation, we've also, with Dodd-Frank, we've created new entities. We've got the OFR and it's collecting a huge amount of data. The CFTB is collecting a huge amount of data now. I mean, millions and millions of records on credit card holders across the country. I'm concerned two things. One is, do the regulators need all that data? But more importantly, now I'm worried about the sensitivity in collecting that data and the safety of that data, because much of that data is very proprietary. And, again, I think one of the things that we would hope that the CFTC and other regulators would do is, look, this is the data we need to make a safety and soundness issue. We don't need to know, that much more about that transaction than a certain subset. And I'm having a hard time believing that we've got 100 fields that that will determine whether that we have the right amount of data on that, and particularly for non-standard trades as well. So, Mr. Chairman, thanks for having this hearing today.
Mr. Aguilera.
Thank you, Mr. Chairman. A couple questions for Mr. Rogers. In your testimony, you comment that in a post-Dodd-Frank world, the Commission has adopted rules for data reporting that have changed how we view the markets. Specifically, can you talk a little bit about the transparency to market participants and give me an example of that? And what do you believe are some of the most significant gains in these efforts? And with respect to SDR data quality, do we plan to continue building upon this progress, and how will we do that?
Thank you for the question, Congressman. I would say that from a significant advancement perspective, that at the Commission, we have a view into the data that we did not have at the time of the financial crisis, and we are actually able to make use of the data that we get through the SDRs every day. Those purposes are to assess exposures for particular market participants and then overall, but then also assess risk, financial risk to firms and whatnot. So we actually analyze the same data that is coming into the SDRs for those purposes. Other purposes would be for the de minimis study, for example, that is currently ongoing or made available for trading. So we have a variety of divisions performing market oversight functions or monitoring swap dealers and or assessing financial risk that are all looking at data that we didn't have a view into before and are able to then do analysis, reach out to industry participants if there are questions that we have about the data and be more informed about what's happening in the marketplace. I think that's the most significant advancement that has been made. I would add that it is certainly there's lots of work that needs to be done moving forward in terms of improving the quality of data, but we actually are using the data on a daily basis. One other thing that I would add is that we are trying to create clarity in terms of what data we would expect to see and how we would expect to see it. That was the purpose of the technical specifications document that was issued with the 120 fields. We believe with that clarity that the quality of data will improve. The quality of the data going into the SDRs will improve because people will know what to submit and when. And that's the objectives of those efforts.
I appreciate it. One more for you. The regulators, the global regulators working on this through the Data Harmonization Working Group to propose guidelines for harmonizing the derivatives data across the jurisdictions. Work streams are taking place on data elements such as unique trade identification, unique product identification, and other data elements. Once the working group puts out its recommendations expected later this year, how will CFTC respond? Will it use these recommendations? What do you think are some of the next steps, and do you envision that there will be changes that are needed based on that work?
Thank you for the question, Congressman. The guidance that's being issued through the CPMI-IOSCO initiative is truly guidance to the regulators on the standard ways to represent this information, with the notion that the regulators that are participating in this activity will adopt that guidance and implement it in their jurisdictions. From a CFTC perspective, we would certainly expect to be implementing the guidance of this initiative. Even at this point, we're looking at how that would be done. So there may be some aspects to the guidance that comes out that would not require a change to rules, but probably would require some guidance from the Commission, and there may be some that would, in fact, require changes to rules. So that's something that we would be looking at, and we would expect that other regulators that are part of the process would be doing as well. That's actually something that we talk about when this committee gets together to discuss the implementation, and that's where a lot of coordination happens, both domestically and internationally, in the work that we're doing moving forward to create that global harmonized standard.
Thank you. Thank you, Mr. Chairman.
Mr. Lucas is no longer. Mr. Lamalfa.
Thank you, Mr. Chairman. Mr. Gill, of course, I'm glad we're having this hearing. It's important to hear from the end users on how this process works or the difficulties of it. Would you didn't have a lot of time earlier. Could you elaborate a little more on the burdens that are imposed on the end users by this amount of data that is required? I mean, would you care to elaborate a little bit more on what that really looks like and what kind of a barrier that might actually be towards trade?
Absolutely, that's a great question. Thank you for that. I think that one way of kind of thinking about it, again, I use the analogy of someone thinking that an email is sufficient. Sometimes people don't realize that an end user also has a continuous obligation to update that information that's posted. So you have to create a system from scratch. You have to create the code in order to actually implement the system. Then you have that reporting obligation going forward in terms of updating that continuous information. Let me take the example of Europe, where that's even tougher. So for example, you have a dual-sided reporting obligation, and usually you would actually rely on the financial counterparty to apply that information and send it to an SDR. In that situation, you actually have to do it yourself. And so the end user has to adopt the system to begin with. So for an international company that's doing both business in the United States and Europe, sometimes they're faced with a situation where they may not have to post that information to report it in the United States, but they do in Europe, and that creates complexity and burden.
And how much do you think that has created a barrier with international transactions?
I think it's been significant, Congressman. I don't have any numbers on
This
me.
isn't the first time it's come up. Ever since I've been in this committee, it's been a topic that has been a source of frustration with trying to, more harmonization is needed between the U.S. and European concerns. Please.
Right. To answer that question, I think it's important to look at how this system has kind of developed over time. So the Europeans have decided to actually develop the system that's very different from the CFTC and what we have in the United States. A few years ago, the CFTC granted no action relief, and it has helped with a lot of these different reporting obligations, which we really appreciate. So, for example, intra-affiliate reporting, which would have been, very burdensome for end users, is something that the CFTC has granted relief from. Europe is different, and because of that, we face different reporting obligations.
The level of detail Mr. Nagelbauer was talking about as well as the amount of data, the number of fields expanding. How do you find that as being really helpful, or what do you think the theory is, or how that would actually be helpful? We have a lot of data. We have a lot of data to keep track of. Is it secure enough? At the end of the day, is it useful to anybody on the regulatory end?
I think you have a great point there, Congressman. The fact is, more information is not necessarily helpful or useful, and we need to actually look at that. So, for example, I'm going to use the example of the EU because I think it's very helpful here. In the dual-sided reporting regime, you have about 50% matching. So, in other words, 50% actually working in that system. You have more information in that system, though, because it's coming from two different sources. Taking that analogy and using it here, now you have 120 new data fields. You might have potential mismatches. You're going to have a lot of false positives. More information is not necessarily helpful in that respect.
It seems like one can get lost in all that, and I don't know if it's even looked at on the regulatory end anyhow. As Ms. Colazzo, I think, alluded to that as well. Mr. Rogers, again, we're hearing multiple times, whether here in this room, I had others in my office complaining about the overload of information as it affects credit unions in the Dodd-Frank situation, and just a lot of frustration with additional, many people feel unneeded levels of information. The harmonization problem across the border is huge since I've been here hearing these testimonies over time. What do you see are really the biggest differences between U.S. and G20 members on these reporting requirements, and what is CFTC going to do to have a much better harmonization so we're not creating a barrier, or even, I think Europe looks at this as hostile towards trade? I'm short of time, too, so you have to hurry, but please, thank you.
Yes, thank you for the question, Congressman. I believe that the work that we're doing internationally with CPMI IOSCO is geared towards in particular, a set of fields that are necessary for aggregation and standardizing on that front. The work that we're doing at CFTC is fitting into that, but when we look at the data that we're asking for, we look at it from the perspective of the use cases that we have at the Commission, and it's based on that the specifications are intended to provide greater clarity for fields that are already being asked for, but then there are also situations where there were new asks of data as it relates to that particular technical specifications document.
I better cut there, but every
Sure.
time I hear about more clarity, it seems to be a greater burden on the people. Whether it's this, whether it's clarity as set down by Army Corps of Engineers on their policy. I'll yield back, Mr. Chairman. Thank you.
Thank you. I'm going to go to a second round of questions pretty quick and try to move fairly fast through these. Mr. Rogers, I've got a couple for you real quick. Does the CFTC have full and timely access to all of the data needed to carry out the mandates of the Dodd-Frank Act to enhance transparency, promote standardization, and reduce systemic risk?
I believe we do have access to the data that we need to, but I do believe that there are refinements that need to be made in that data in terms of the quality of it, whether it's complete or whether it's accurate, and we're taking steps in that regard. There are circumstances where data has been identified, new data that would be required, but for the most part, I would say that we do have access to the data to perform quite a lot of the functions that we are required to perform.
Do you or does any other authority have a global view of the swap markets?
Thank you for the question. I would say that at this point in time, no. We have a view into the data that we have jurisdiction over, and that gives us insight, and we would have to reach out then and get data that we would need in a broader context. It is an issue that is being worked on through the Financial Stability Board and CPMI and IOSCO, but at this time, the mechanism that would be envisioned to have a single place where every jurisdiction could go to do that assessment is not in place at this time.
Why not?
I believe that it's a complicated matter that requires examination from a variety of different fronts. One of them would be the legal barriers. And in the U.S., we've just had the repeal of the indemnification provision. But in other jurisdictions, there are similar barriers to having that information being shared. Other laws, like privacy laws and things like that, there's governance and data protection things that would need to be worked out to make sure that the data that would be available is available in an appropriate way and protected properly and used properly. So those are just a couple of issues that would be need to be addressed to stand up a regime like that.
As you work through that, I think it would be helpful for this committee to have those recommendations, especially on how we protect people's privacy while at the same time making that data usable. One more question. Within the confines of your recent appropriations, what work are you doing to improve the technological capabilities of the Commission to accept, process, and analyze swaps data from the SDRs?
Thank you for the question, Congressman. We are working on a variety of fronts, starting from the technological layer. There are cycles to technologically refresh our environment. So as an example, our storage capacity is something that we are addressing this year. From a more data-oriented perspective, we are working very hard to provide specifications that will hopefully improve the quality of information, but also working on the systems that are necessary to combine data from multiple swaps data repositories in such a way that our staff, regardless of the divisions that are represented, can go to one place and do the analysis that they need to do to carry out the mission of the Commission. So quite a lot from both the technological front and from the data perspective.
I've got one more question, if I may, Mr. Scott, before I go to you. Ms. Cruz, it was mentioned the importance of using existing market conventions. What are those market conventions, and what are we using instead of those conventions?
Sure, thank you, Mr. Chairman. It's a very good question. The conventions, the key ones are the following. There are ISDA product definitions that have been published and developed over time that are used by market participants to agree the terms of their transactions and confirm the terms of the transactions. They establish terminology and definitions for terminology that, frankly, just are the market standard for how derivatives are agreed and confirmed. Yet those terms and the definitions that underlie them aren't being consistently used and leveraged. Instead, you have regulators creating new terms to represent the same information or defining it differently, which isn't really economically what was agreed between the parties. Also, from an electronic representation, there are standard ways to represent some of this data. A lot of that is in the financial products markup language. This is an open source electronic messaging scheme that is used by market participants even before their reporting requirements to electronically confirm the trades. So there already is a mechanism to represent consistently, for instance, things like business day conventions established in these, or certain dates and payment types, et cetera. And those values are not necessarily being leveraged and reflected in the regulatory requirements. Instead, regulators start fresh and kind of reinvent the wheel to come up with their own values. If you go back to these standards and regulators align to them, it not only increases the efficiency of reporting, but increases the consistency between the regulatory requirements.
Well, thank you. Mr. Scott.
Yeah, thank you, Mr. Chairman. So this morning we've heard from the panel, Ms. Cruz, Alacio, and you, Mr. Gill, that we have global regulators that are working together with the CPMI IOSCO Data Harmonization Working Group, and they will propose guidelines for harmonizing derivatives data across all of the 9 jurisdictions, according to Ms. Galasso. And that work streams are taking place on data elements such as the unique trade identification, unique product identification, and other data elements. So then I got to turn to you, Mr. Rogers, and ask you, once this working group, as your 3 panelists have laid out, puts out its recommendations, which I understand is expected later this year, will you, the CFTC, heed those recommendations?
Thank you for the question, Congressman. So let me provide a little context behind the recommendations that are coming out from the CPMI IOSCO group. They are focusing, besides the UTI and the UPI, on 80 fields that are necessary for the aggregation of data. And within those 80 fields, yes, the CFTC does plan to adopt the recommendations of the group. The needs, though, in terms of what the CFTC does with data actually is broader than the mandate of those 80 fields. Mm-hmm. And that's why we have in our technical specification that's come out 120 fields, as an example, actually covering 3 asset classes: credit, interest rates, and foreign exchange.
Right, so your answer is that you will heed the recommendations. Now, let me give you this entrance ramp by asking you that if you do you envision that there will be changes needed to current rules and reporting requirements based on this work?
Thank you for the question. I believe that there is certainly the possibility that would exist. I don't know that I could say categorically, but I believe that is in all likelihood a possibility. I think that, for example, in our Part 45 rules, there are very specific appendices in the back of that, and there might be adjustments that are needed to that, but there could be adjustments in other areas. One of the things that we are looking at from a commission standpoint is the potential for changes to our rules based on information that we know now, but also I could envision that changes would be required as it relates to that work that's being done by CPMI and IOSCO.
Okay, let me ask you, each of you, to comment, if you could. The data quality in ICE swaps data repository is high, very high. There's a high bar for data to make it into the swap data repository, and many validations are in place to ensure data quality. All of the SDRs have been working together to present data in the most efficient manner. And the suggested path forward is to allow the SDRs to work with the CFTC. And I've been assured that this is a very achievable goal. Yet, there is still talk about improving the quality of the data. So my question is, what is the best path forward to improve that data security, quality? Yeah. Mr. Rogers.
Thank you for the question. I think that from the CFTC's perspective, as I mentioned in my opening remarks, I believe that in some cases, the swaps data repositories don't feel that they are empowered to reject data. And if we provide greater clarity on, one, that they can, and two, just what the criteria it would be for validation, that whether it is making sure that data that is not supplied is now supplied, or more complicated things around data quality, that will substantially improve the quality of the data coming to the commission. And so that is a priority focus of ours.
All right. Thank you, Mr. Chairman.
Mr. Lamotha?
Thank you again, Mr. Chairman. Mr. Gill, listening to the complexity of this today and over time, there's certainly a case to be made. Is there can exceptions be made from some of these reporting requirements at a certain level or a certain timeline? And would you have any recommendations on that? Would you be supportive of that? And how would, if you would, how would you put that into place? How would you implement that sort of thing?
Thank you very much, Congressman, for that question. I think it's completely appropriate to be looking at this, looking at the burden that's imposed on end user companies and finding out if there are exemptions or abilities to tailor that type of reporting in a way that will be appropriate for end users. In terms of specific recommendations, it's difficult to say, considering that this was a technical staff document out for proposal. I think the main point, though, and the main point that I underscore that I think the other panelists have also mentioned, is that it's incredibly important to make sure that it's consistent with the work being done by CPMI IOSCO. It needs to be consistent. End users that especially do businesses across different jurisdictions need to have the same reporting obligations throughout.
Okay, let me shift to Ms. Cruz too on that. With I picked up that you were talked about the reinvention of the wheel, where there had been a way of doing things that was working, and now you have to almost scrap that in order to have these two different languages talk to each other in really plain terms here. What would you see as the concern about the previous way of doing things as being deficient? Where's that concern coming from, and what are these? Elaborate more on the pitfalls of having two different methods of doing that with this reinvention of the wheel, as you mentioned.
Thank you, Congressman. I mean, the real pitfall is that it's very inefficient, right? It also creates a lack of clarity. It allows participants to interpret the data in a different way, potentially report it in a different way, and in a different way than the way they might have agreed the trade or the way they might have confirmed it bilaterally between themselves. Ideally, if you want good quality data, you want the data to be provided to the regulators and viewed by the regulators in the same terminology and in the same form and as close to the same form as the parties agreed it between themselves to begin with.
So the industry standard amongst the people talking to each other doing it should be adapted to by the regulatory agency so that you're going to get better quality instead of trying to translate into something completely different that they don't work with, basically?
Yes, that's correct. I mean, a lot of the issues you see with data quality are not attributed to the fact that the parties don't agree on the terms of the trade. They've confirmed the trade. They have legal certainty. It's the way the data is transformed differently by parties, sometimes due to technological differences in their systems, sometimes due to different interpretations of what's required or asked for by the regulator, that ends up showing a disparity.
What is the quality of the technology that the regulator brings to the table compared to what you have within your system?
I think it's more so about the regulators adopting what's already available from an industry perspective, because parties use those standards to provide the information to the regulator, and then the regulator can leverage and benefit from those existing standards. It ought to save them a lot of work, and it ought to provide a mechanism for more consistent data.
Thank you. That sounds sensible to me. Ms. Colazzo, you talked about having like an international governing framework here where you'd have more, in order to cover this international misunderstanding here, that you would have an outside group made up of multinational entities to speak to each other about that, come to agree. Could you elaborate on how that would come about? How do you envision that, and how would that be formed, or what would it be accountable to?
Thank you for the question, Congressman. In terms of the governance model, it's really a jumping off point from what Tara Cruz just discussed, which is there are existing market standards, and our hope and expectation is that those standards are recognized at a global level. But we also know that standards evolve over time. And we don't want it to be...
I'm sorry, it's running out of time, but how would you formulate this international
governance.
entity or a governance group that would be trying to assemble this? How would that come about?
Right.
If you could please.
So essentially what we would like to see is that the governance model is such that it has representatives from each of the jurisdictions, major jurisdictions that have derivatives data, and that they are constantly, that they can take inquiries. It can be a governance model that is owned by the industry, such as, ISDA has particular governance oversight of certain data elements. Regulators representing multiple jurisdictions can be part of that governance framework. And then there can be a process for, as the standards evolve, for this governance framework to review it, to comment on it, and to make sure that it's aligned with how entities would report and the changes they would have to make to
Okay,
this.
to sum up then, would they have any kind of regulatory authority, or is it more of a recommendation that has credibility amongst all the separate groups that should be paid attention to? Are you going to empower them with some kind of enforcement or some kind of regulatory?
I would say it's a great question. I would say that it's more about enabling the standard to evolve, and that the regulation recognizes that governance framework so that as changes occur in the market, the data is consistently being updated on a global basis.
Thank you. So they could be listened to and with credibility. Mr. Chairman, thank you for your indulgence. I yield back. Thank you.
Thank you, Mr. Lamalfa. We'll take that minute and a half out of the next meeting. Mr. Davis.
Thank you, Mr. Chairman, and thanks to all the witnesses for being here today. I'd like to start with Mr. Rogers. As the CFTC pushes to develop these standards to report each and every swap trade, are precautions being taken to ensure that such rules don't end up hurting liquidity, because reporting actually imposes real costs on the market participants?
Thank you for the question, Congressman. Yes, I would say that the data that is being asked for is being looked at in terms of the implications for the use by the Commission and on the marketplace in general. We have focused on, in fact, in our technical specifications, existing standards, existing practices, and look forward to feedback on exactly what we're asking for and how that fits into the framework that already exists, with the notion of trying to ensure that we're able to accomplish our regulatory mission, but also trying to not be overly burdensome to industry.
Okay, Ms. Cruz, does industry feel the regulators are only demanding the information they need or expanding into new fields?
I would, thank you, Congressman. I mean, we definitely feel that they're expanding it, right? I would really question the idea that the 120 fields in the technical specification are all priority fields. Many of these are new fields. There's probably a couple dozen of them that are brand new fields, which is an expansion of reporting requirements. At this point in time, people feel it's more important to focus on improving the data fields that are already required by the Commission and making those more useful rather than looking to expand the scope of the requirements.
Okay, now we know every SDR is going to need to make some changes to comply with this uniform reporting standard. Are you concerned that the regulators won't give industry enough time to implement some of these changes with the fields that you've mentioned? Ms. Cruz, you? Go ahead.
That's for me. Congressman, thank you for the question. Yes, it could take significant time. I mean, one of the concerns that we really have is that we don't want jurisdiction-specific implementations. We want the global initiative at CPMI-ISCO to play out, and to the extent that there are changes that are necessary to promote consistency, which there probably will be, then the industry is very willing to do that, but they want to do it in a globally coordinated fashion. It's very expensive and inefficient to have interim jurisdiction-specific changes to regulations, especially if those might then be superseded by the global mandates.
Okay. Well, I guess for the other two witnesses, do you have any comments on any of the questions I've asked?
I would add one other comment in terms of the data and having a much more narrow focus on improving the quality there. Really, it's about the ability, when we think about usability, it's about transforming this data into information. And the only way to do that is to have a consistent standard. So we would absolutely agree that narrowing the focus on what are the key economic terms, what are the key data elements, for example, the parties to the trade, that are needed to be able to aggregate and have useful information. Data in and of itself is not information. And so when looking at that, we think that there is a much more narrow set of data elements. In fact, we did suggest to CPMI-ISCO that that data set is somewhere in the vicinity of 30 to 50 fields. And we made that specific recommendation on those fields for credit derivatives. So we would really urge that there be a much more narrow lens around these data standards, that the focus is around how would that information be used? What aggregation, what output of the data would be utilized by the regulators? And that's the objective that we should be turning our attention to.
Okay, thank you. Mr. Gill?
I would associate myself with the comments of Ms. Cruz and Ms. Colazo. I would also add...
Not Mr. Rogers?
Not Mr. Rogers.
Okay.
What I would say, though, in addition to the points that they raised, we have to look at what tools are also available currently to talk about swap data quality. And, for example, portfolio reconciliation and confirmation of trades, those basically ensure that the economics in the bargain that are actually entered into between parties is confirmed. And so when we're talking about data quality issues, we're talking more about month, date, year versus date, month, year kind of issues, not the economics of the actual transaction.
Great. Well, thank you all very, very much. Mr. Rogers?
May I add something? Yes.
If the chairman allows me extra time, you can.
Absolutely.
Thank you.
Thank you both. So I would say that, without question, we are looking at how the global standards align with the things that we're asking for. And a real good example of that is the UPI data element. We've been having conversations with industry for a long time about the unique product identification and how to represent that. And we're specifically asked, please don't create something at the commission that would then be overtaken by an international standard. And it's for that reason that is an element that hasn't been brought into the conversation. We work very hard to align what we're doing domestically with what's being done internationally, and do try to leverage international standards. Having said that, we've gotten feedback at our TAC meeting this week that some of the things that we were asking for in our technical specification did represent more things that we were asking for, and heard very clearly that the recommendation was focus on the making the elements that we already have better before asking for new elements. And that's something that we will absolutely take into consideration as we contemplate the comments that we have gotten or will be getting as a result of this
I
proposal.
think from some of the questions we've asked, I respect the fact that the CFTC is willing to take those ideas into consideration. We would urge that to happen, and we appreciate your willingness to work with us, and thank you all for being here, and I don't have any time to yield back.
Thank you. Mr. Kelly.
Ms. Cruz, the CFTC swap data reporting requirements are not fully aligned with the SEC's requirement for security-based swap data. Differences exist as to who is obligated to report, reporting timelines, and what data is reportable. What is the impact of these discrepancies between the SEC and CFTC's swap data reporting standards?
Thank you for the question, Congressman. It's an excellent one, and one that I've been quite concerned about. We've been working with the CFTC and providing the SEC and providing comment to them as they've worked to finalize their rules. And one of the major comments that our members have continued to put forward is that the SEC should be working to try and align with the CFTC to the greatest extent possible. What it means for market participants is a great deal of additional cost and inefficiency because they have to build out different reporting pipelines, different reporting logic, different reporting data fields for their security-based swaps as they're currently reporting for their swaps. It also creates a great deal of expense for trade repositories that are looking to support it. That cost gets passed back to the market participants. The SEC also has a requirement that goes to the end users very specifically. They're looking for the party who is not responsible primarily for reporting to supplement the data with unique identification codes like trader IDs and trading desk IDs, which amounts to requiring these parties to onboard to all of the trade repositories and build out their own pipelines to report additional data.
And if I mispronounce your name, I apologize, Ms. Collazo. If you or Mr. Gill, I noticed you were nodding during some of that. If you have comments that you would like to add, I'd sure appreciate it.
Thank you, Congressman, for the question. I would absolutely agree with the comments that Ms. Cruz made. And this is a real concern because we've talked about globally, but even domestically, we have these challenges. We're very concerned about the impact that it will have in terms of the quality of the data that we'll receive. These types of fields that are additional fields that are being recommended by the SEC is not information that's otherwise held in a systemic way. And so even, there are challenges in adhering to it in terms of the end user impact, how are the swap dealers to gather this kind of information as a swap data repository? How can I rely that that information is actually accurate? And it's also morphing into concerns such as, personal information. There are additional obligations that the SEC regulation has about a swap data repository being an issuer of these identifiers. And we do not believe that that is a role that a swap data repository should play, and we question the value of that measured against, the information that would be derived.
And I apologize, Mr. Gill. I wanted to give Mr. Rogers just a chance to respond, and I'll come back to you if I have any time. What is the CFTC doing to harmonize the data reporting standards with the SEC, Mr. Rogers?
Thank you for the question, Congressman. I know that SEC and CFTC, from a mission policy setting direction, do coordinate the activities that they have going on within their particular purviews. I can also say that the SEC does participate in the CPMI IOSCO initiative, and that's a means of collaboration between our organizations at the very specific data level. Of course, it's up to the particular jurisdictions to adopt the recommendations that are coming out of this initiative, but we would expect that everyone would be adopting it. So there's coordination at the very specific data level, but there's also coordination at the policy level.
And Mr. Gill, you've got my remaining 30 seconds.
Thank you. I would only add, in addition to the differences that have kind of been noted here, is intra-affiliate reporting. And so the CFTC and its no action relief granted relief from that in its reporting rules. The SEC seems to be going down a different route and will require it, despite the fact that it's internal risk management. So end users find that to be a significant concern and will be inputting comments on that.
Thank you, and Mr. Chairman, I yield back.
And that is right on time. Ladies and gentlemen, Ranking Member Scott and myself, we would like to thank you for coming and testifying before the committee today. And under the rules of the committee, the record of today's hearing will remain open for 10 calendar days to receive additional materials and supplementary written responses from the witnesses to any questions posed by a member. The Subcommittee on Commodity Exchanges, Energy, and Credit hearing is now adjourned. Thank you.